G'day, my name is Avery. I'm the first lawyer to speak here, and in relation to Villamanta Legal Service for whom I work, Villamanta is a community legal service. It assists people with intellectual disabilities, predominantly where the disability affects the legal issue or the issue affects the legal issue, the disability. It's a very wide-ranging service, and we are the service of last resort, which means that somebody goes everywhere else and finally gets told, well, Villamanta might be able to help you. So we tend to deal with everything from criminal proceedings in the magistrate's court to family law to administration and guardianship orders, a whole range of odds and ends. We don't do wills, but we can give some advice. But it's a whole range of odds and ends, but predominantly with intellectual disability. But because we are a last resort, we always get people who have ABIs coming to talk to us as well and seeking our legal advice. Sadly, because funds are limited, we often end up doing our own court advocacy as well, even though we try and get some pro bono from barristers. It is difficult to ask the same barrister to assist us all the time. So that's Villamanta Legal Service, and we're statewide. Okay, in relation to what we're talking about, I'm going to be talking about accessing legal services, a little bit about the police interviews, which is going to be interesting, and of course about services which are available, which are not as punitive as some of the penalties that you get in the Sentencing Act. So let's quickly start. Essentially what happens is that you have a client. This is all about you, and hopefully the theme that runs through this talk is about you assisting the client to assist the lawyer. That's the whole point about this. There are 4 occasions where a client will come in contact or have need for a lawyer. The first one, of course, is they accompany the police to the police station. They receive a charge and summons. They need bail, or last but not least, and the one in which we get 90% of the contacts is when they actually attend court on their first or second court day. And for those lawyers who are in the room, it's often the second court day that we actually get contacted, which is a bit of a problem because we've already had, or they've already had, what's called an administrative adjournment, which means the magistrate gets really, really annoyed at us because our client hasn't come to us earlier. And this is really important. So, there's legal services that are available, and we'll come back to why that first slide was important in a moment. The legal services that are available are legal aid, a legal aid lawyer who is approved by legal aid or private lawyer approved, a private lawyer who the client pays for, of course, and a duty lawyer. And often there is the community legal centre that can assist as well. Now, they all have their own functions, and the issue with legal aid is problematic. Legal aid, as you may be well aware, has cut back funding quite considerably over the last few years, particularly in the change of governments. Not having a go at governments, and perhaps I am. In terms of getting legal aid, a client has to satisfy certain requirements, and those requirements are pretty straightforward. To get legal aid for a criminal matter, it's predominantly that they need to, the matter is likely to end up in them going to jail. It's a simple test. There are other tests. There's a financial test, which is the assets and incomes test. But the first thing is that they're not going to get legal aid unless there is the probability they're going to go to jail or be incarcerated. Now that's a test, and that's a very basic way of putting it. It's not the correct way of putting it, by the way, but it shows that legal aid is exceedingly limited. The other problem for legal aid is that legal aid will often say to a client, look, we've got a conflict, you'll have to go somewhere else. Or they'll say, we can't help you, and the client's then left in the lurch. And what happens for social workers and for workers who assist clients is that there is another option, and that is a legal aid approved private lawyer. And that legal aid approved private lawyer can take on that client under the same conditions. That is, there is a test that needs to be adhered to for that person to be able to get legally aided assistance within the court. If, however, the client needs bail, there's a slightly different test. A different test in bail is not that they are likely to go to jail. They're already probably incarcerated, which means they're there. So the test for legal aid is that the test is that there is a good chance that they're going to get bail, and that the police oppose bail. So, and that's a test which the legal aid or the legally aided private lawyer needs to put in the application to get assistance to assist that client. Now that application can go in after the fact, with a bit of a problem if it's not back. So just be aware, if the client comes to you and says, look, I want help, or I'm stuck in jail, it's actually not jail, more often the cells, I need help, then they may well be told there isn't any help because the legal aid is not available to them. Now, in terms of bail, there is a benefit. If the client tries to get bail themselves and they fail, then a lawyer can come and assist for the second bite. If a lawyer tries the first time, there is no second bite, except it can go for an appeal. Okay, so legal aid is problematic because there's not a lot of money available to the people. Okay, just quickly go back. Community legal centres can assist, and Fitzroy Legal Service is the gold service of Victoria, as we're well aware, and many of the others. The issue there is that some community legal centres are not funded to attend court. Some are funded to attend court for specific issues, such as intervention orders. So it's very difficult sometimes for the client to get assistance, and you've got to be aware of that in helping the client. So often they're left to their own resources, and they have an ABI, and they have an ID, and therefore they are exceedingly disadvantaged within the system, and hopefully the duty lawyer can assist or give some assistance. The problem for the duty lawyer is that, as I said at the very beginning, the duty lawyer is contacted on that first or second court date, and they don't have a lot of time. Okay, so if they don't have a lot of time, the client comes to them, the court is at 9:30, it's now 10:30, they're about to be called, and the client says, I need help. How does the lawyer assist the client? Well, they've got to get instructions. And getting instructions from a person with an ABI or an ID, particularly because the lawyer is not a qualified doctor, they're not a psychologist, they're not a psychiatrist, they need to get as much information as they can. The question is, can the worker, if there is a worker with them, assist the lawyer to get instructions? And many lawyers will say, no, it's privileged, go away. In fact, Section 119 of the Evidence Act does give them an in and allows them to do it. Sorry, I can see that those people who are lawyers are squirming with delight because I'm talking about legislation, and the other people are not. But Section 119 may assist. The difficulty is that some lawyers will accept that a social worker can sit in the room to assist. Some lawyers will not. It does depend on the law, and it's your personal interaction with a lawyer that may be able to persuade them. Essentially, what needs to happen is that the information, as a worker, you cannot give instructions. You cannot tell what happened. You cannot do that. You're simply there to assist the client to understand and to assist the client to give their information to the lawyer. It's really that simple. You can't give any other information. That's not your job in that interview, because the principle is that what you're doing is you're presenting confidential information to assist the client to the lawyer for the purpose of that court hearing that is to occur. Again, it's really important that this is a very difficult area to deal with, because most lawyers have had the interesting experience of having parents in the room telling them what their sons have done, the interesting and awful experience of a DHS worker, sorry if there's any DHS workers here, telling the client did it, and then they should do it, and the lawyer is therefore getting instructions from that person, not from the client. So it's very important for the lawyer to shut that person down and say, what you're here to do is just to help me pass that information to and fro. Villamanta actually have a form which we get the third person to sign, which actually summarises this section of the Act. It has no force in law, and I shouldn't really tell you this, but it scares the bejeebers out of people. And it says, okay, well, you sign this information is privileged. Actually, it's confidential, we don't tell them that. But that form gives that person the idea that they can't disclose anything that's said in that room. Okay, there are other services available. I'm sorry this is a very dry talk, but actually it won't be fairly soon. There are other services available. The Law Institute of Victoria can refer you off to people that might be able to assist you, those lawyers. Pilch, which is now called Justice Connect, again is a service which can assist you to find a lawyer or barrister for your client. And Law Aid, but that's really only for civil litigation. This is the interesting bit. Police interviews. Well, not actually. I understand that my friend was at Geelong last year, and there was a dispute between the gentleman who ran the discussion last year, and I'm not sure if there was my colleague was quite vibrant about it. It's about giving police the information they require. The first stage, of course, is that the police can stop you in the street and they can ask you certain questions. Now, there's no obligation to give the police any information except your name and address. Well, sort of. Sorry about that. If the police believe you've committed an offence or about to commit an offence, they can ask your name and address. If you're driving a boat car, they can ask you your name and address. On public transport, that can occur. A name and address can be given. In a pub, or if the police believe that you can assist them investigating an indictable offence. Now, that's actually if the police believe you can assist them to investigate. It doesn't necessarily mean you're the accused. It means that can also be somebody who's a witness. Also, when asking you or telling you to move on. There's no obligation to accompany them. Well, sort of. They can ask you to accompany them to the station if they're arresting you. Well, that's not really asking you, that's telling you. You're driving, they want you to do a breathalyzer test or a drug test. Well, that's not quite correct. They can ask you to come and you can say no. Problem is, you're then charged with failing to accompany. So you can say no, so you've got to have a really good defence. And I had one recently, but my client stuffed it up in the witness box. Okay. Investigating family violence, as we've said before, the police can say to the person, you must come with us to the station. Or they believe that you are mentally impaired and need to be involuntarily admitted, and that's an assessment that needs to be made. So in most cases, the police, in a sense, are limited in asking you to accompany them to the station. The question is, however, do you accompany them? And do you give a no-comment interview? And it's not as simple as saying you should or you shouldn't. A client has a right to remain silent. This is the basic law. They have a right to communicate and obtain legal advice. In fact, they've got the right to communicate and tell a friend that they are there. Particularly, this is a significant issue in relation to people with ID and ABI. You have a right to ring a friend. It's put as simple as that. If you have an ID or an ABI, what does that mean? Okay, I've got a right. There's an inference in there, and the inference is that you should make that decision to do so. But often people with IDs and ABIs don't get that level of abstract language. It's very, very concrete. You've got a right. I had a client one day who was in a room with me being interviewed. We were interviewing, and his mother was sitting there. We got her to sign the form, by the way. And he said something. She said, pull your head in. He had a polo neck shirt on and literally pulled his head in. Sometimes the level of language understanding is so concrete that it's very hard to communicate what the issues are. But they have a right to. And this is an you should have an ITP. As was said before, it's in the police manual for that to occur. Okay, the right to remain silent is a choice. Again, bit of a problem if you've got only concrete language. No adverse inference can be withdrawn from it. In other words, the courts can't say, well, you decided not to say anything, so we're going to hold that against you. Very famous case about a boat, but we won't go into that. A no-comment interview must give your name. You must not answer any further questions. You cannot choose which questions to answer, but you can say no comment or I'm not answering or whatever. However, you've got to carefully consider this. And what happens first of all before that occurs is you need to speak to your lawyer, or you need your client to speak to the lawyer. And what the lawyer should then do is, first of all, talk to the informant. This is an information gathering to assist the client. They get the details of the alleged offence if they can. Most informants are exceedingly helpful. Work out what the likely charges are, whether there's anything to suggest the client has an incapacity, whether there are any previous convictions, and what the police attitude would be to things like diversion. And it's really important up front to try and get that information if you possibly can. Then the client gets to talk to the lawyer. At this point, the lawyer has some information, and the lawyer can advise no comment interviews. And that's the default. But it's not the be-all and end-all of the decision. What the client and the lawyer need to look at is all the circumstances. That is, Is the evidence overwhelming? If the evidence is overwhelming, it may well be that it's a benefit to the client to admit or to give a comment interview. The difficulty for a person with an intellectual disability or an ABI is that issue of what was mentioned before, the mens rea, an understanding of whether or not what they've done is wrong. And this is a significant issue for the lawyer to assist that client. Cultural background may be important. The weakness of the case. If the case is weak, we may suggest no comment. Depends on the circumstances. The previous experience of the client, as was indicated before with the gentleman with the pink suit, whose name I don't remember, Damien. His experience with the police was difficult. And the ITP, this is really, really important. Having an ITP present and letting that ITP know up front that the person has an ABI or an ID. The difficulty there is, what does that ABI or ID mean for that person? It's not the medical definition that's relevant here, it's the social definition of disability that's relevant here. The social definition of disability relates to the condition the person has, the restriction that condition leads to, and whether or not they have a disability. So, for example, they have a frontal lobe injury. It may mean that they have significant behavioural problems. What does that mean in terms of their communication style? And it's very important when advising a client to look and let the ITP know, because that ITP, as you heard before, has an obligation in a sense to make sure that the client understands the interview, understands the question. And it's very difficult for an ITP to do that if they don't know that the person's intellectual disability, for example, means that their language is exceedingly concrete. I had a client in an interview and the police said the right thing, you have a right to blah, blah, blah. Do you understand these rights as I read them to you? He said, yes. The policeman, to his credit, tried again. And when he made the language much more simple, well, you can ring your mum if you want. Do you understand? He said, no. Which was clearly an issue about comprehension. Well, why would I want to ring my mum? I don't know, because I don't, whatever. And the difficulty there becomes that the ITP person can then say, look, perhaps we could rephrase that, perhaps we could do that. And that's why the ITP has to know. The question you have to ask yourself is, who tells the ITP? You? Privacy. The lawyer? Privacy. The client? Who knows? Okay. Alternatively, you can suggest to answer the questions. Again, we say, is there overwhelming evidence? Is there a possible lesser penalty? Is there a viable defence? I was in Ireland at the time. I wasn't there. It may, sorry about the accent, I can't help that sometimes. Again, cognitive capacity is sometimes a defence. It's really important. Sadly, importantly, this is not England, it is not America. The lawyer does not attend the interview. There's a good reason for that. The lawyer actually, if the person made an admission, that admission is not in a privileged interview. Therefore, that lawyer can actually be called as a witness. Bit of a problem, that. So lawyers don't normally attend interviews. That's just why you want an ITP with all the information. Sentencing and court options. Here we go. Non-sentencing options. Well, diversion. Actually, I'm going to digress from what I was going to say. Consider this, to those people who are not lawyers, to those people who are lawyers. When you plead guilty, you admit to the physical action of doing it and to the intention to do it. I actually picked up that chocolate bar and I walked out the shopping centre with it with the intention to eat it. I know that I wasn't going to pay for it. Okay? Let's ask you now to take responsibility for under a diversion. You are saying you took the chocolate bar, you intended to eat it, and you intended to not pay for it. Who in this room understands the difference between the two? That's a good answer, because I don't. In fact, the difference is the effect that has on the decision of the court. It is so difficult for people who don't have an ID or people who don't have an ABI to understand the subtle difference between saying I take responsibility or I plead guilty. The effect is different. The effect is you don't get your name on LEAP, because there's no determination of the court. I think you don't get it on leap, but you don't certainly get it. No, well, you don't get it on leap. It's not on leap, is it? It's not on leap. You'll still be on leap. Okay, but you're not convicted of an offence. There's no conviction. Even, by the way, non-convictions go on leap. They are a determination. Okay. Generally, it's a first-time offender. Generally, you've got to acknowledge responsibility. I don't know how the hell you're going to explain it to your clients. Police can caution people. That can be for under 18 years and over 18. More often, it's under 18. A lot more under 18-year-olds get cautions. Ropes, only if you're under 18. Great program. If you ever get the chance to go and do it, go and do it. It actually means climbing up and down walls. Or police warning, by the way, police warnings apply to everyone in this room. If you've been speeding and it's a first-time offence, try and get a police warning. Okay, principles of sentencing. This is really important because a sentence should not be, there's lots of principles and whatever, not more severe than necessary to achieve the purpose. In other words, it shouldn't be crushing. In other words, you don't send somebody to jail for stealing a chocolate bar. And yes, I had a client with an intellectual disability who was charged for stealing a chocolate bar from, I'm not going to say the shop. Problem was there was no evidence because he ate it.
Isn't that a good thing? No,
I'm not sure. But he wasn't going to go to jail, and that's the crushing sentence. So it's got to be no more than is absolutely necessary. The difficulty is, again, with people with IDs and ABIs, the question is, how do we make the penalty, the assistance, such that they're not going to reoffend or not likely to reoffend? Take into account the mitigatory circumstances of the offender. Today, tonight, the Daily Mail, the Herald Sun, all say, oh, well, you know, they said that he had an intellectual disability or they had mental health issues, and they don't tell you the rest of it. Mitigation is not about the person had an ID or the person has an ABI. That's not what it's about. Mitigation is essentially trying to tell the court this is not likely to occur again. Again, go back to the social definition of disability. The person has an ID, they may have an ABI, they may therefore not have the same reticence to do things. What can be put in place to assist them to overcome that lack of control? And that's what mitigation is about. It's about trying to persuade the magistrate, in most cases, because this is the jurisdiction in which we deal, that it's not likely to occur again, or it's a once-off. Structure, and I'm not going through this, it's pretty straightforward. You're going to get copies of this PowerPoint. This is the structure of the harsh penalties, the penal penalties. By the way, it can be dismissed. There's a fine. There's community corrections order, which is actually quite good corrections order, but they can be accompanied by fines, drug treatment order, suspended sentence, or imprisonments, and that's the structure. But we're more interested in making sure, or trying to find that the client out whether the client is not likely to reoffend in the future, and that's where the court services come into play. Okay, KISP, Court Integrated Services Program, and we have somebody at the back who knows this far better than do I. It's a program to assist. The objective is to reduce reoffending. It's only in a small number of areas. It addresses them by linking clients to services. It links clients to alcohol and drug services, ABI assistance services, accommodation services. What's important and interesting about KISP is there's no need for a guilty plea. In other words, you don't need to say, I plead guilty. It comes before that. And the idea is if you complete the program, that is part of the assessment from the court as to what sort of penalty, if anything, that should be given. Who can refer? Lawyers, police, magistrate, court staff, family, friends. I've put workers in there. That's not actually in the material, but I would wonder whether or not a worker could persuade the police or the court staff to refer the client to the KISP program. You can be on summons, you can be on bail, and I've given copies of the pamphlets for each one of these programs as we go. There is some similarity between KISP and ARC. ARC, by the way, the difference is that you must have pled guilty, but it is directed towards people with a mental illness and a cognitive impairment, and the definition is on the next slide, and it's quite broad, which is really, really useful. It does again address underlying issues of the offending conduct, and that's important. It does reduce the number of offenders entering the prison system, and it does it in a very effective way. And of course, because the KISP is a integrated program, it does work well with those. There is an issue of consent. The client must consent to doing it. Again, if you've got an issue of ABI and ID, particularly if it's a significant intellectual disability, particularly if the offending is ongoing and is not likely to change, that's a significant issue for this program because it's got to help. Reports are really useful. Neuropsych reports are quite useful. But just to diverge for a moment, I'm not in terms of neuropsych reports, there is a question in the law in relation to neuropsych reports. And we have to be aware that a neuropsych report is not determinative of the outcome. So a neuropsych report may well say a person has a cognitive impairment, their executive functions are impaired, therefore there is a probability or propensity for them to do A, B and C. What I want workers to do is and programs to do is to assist me to overcome that propensity. Again, go back to social definition. There is a condition. The condition is they have an intellectual disability. There is a limitation. The limitation is they have a propensity to do something. I want to overcome that propensity by being able to say to the court, okay, but these services are in place, or he's done these programs. Sorry, he, she, whatever. Credit bail, brilliant service. Credit bail assists offenders who are on bail to avoid remand by accessing services. It's in quite a number of areas. And again, there's no need to have entered a plea. By the way, in relation to not entering a plea, there's no admission. Just because you do the credit bail, just because you enter the KISS program, is not an admission you've done something wrong. Well, people can interpret it that way, but in law, it's not an admission. Credit bail is really important because a lot of people who have ID, who have an ABI, are homeless or likely to be homeless. Or, for example, if they are charged with an offence because of a family violence matter, they may well not be in their own home. So they could end up on remand, and the idea of credit bail is to give them assistance to not end up in remand. Okay, the next 5 or 6 pages are resources for you to get whatever you want, to do whatever you want with them, whatever. I'm not going to go through them, but they cover the areas that I've given the monologue on. So I suppose the question is, are there any questions?
Well, the people in this room who are predominantly service providers, we've got lots of sentencing options, diversions and KISP and ARC and so on and so on. If one of their clients is in trouble with the justice system, well, a story I hear often is that they might have a legal aid lawyer. Yep. And the therapist or service provider is saying, well, I'm not sure it's going particularly well. You know, they're very busy, not enough resources. How do the people in this room who can make positive contributions to things like court orders and ideas for conditions that will affect the person, how can they best jump in and at what point to assist the lawyer and assist KISP and ARC and so forth with their knowledge?
Okay, if the knowledge relates to specifically the client, not the offence itself, and that's important, and we indicated that before, it depends on your personal skills, or your interpersonal skills with the lawyer. Most lawyers, I think, will take on I shouldn't have a go at lawyers, I'm one myself. Most lawyers will take on the information if it's useful to them. So providing reports, providing background information, as long as you've got the consent of the client. Because remember, a lot of the information that you gather is private, is confidential. That may well assist the lawyer in forming if the client pleads guilty, forming the mitigation submission. That is please your honour, don't send them to court, don't send them to jail. Please your honour, my client's on a pension, he doesn't have a lot of money, and we could afford $2 a week. Anything that might assist the lawyer, as long as it's in a relatively straightforward form, is useful. But it's right, it depends on time, resources. It's even worse for community legal centres. I work 4 days a week, 5 days a week at Villamanta. I work 4 days, 5 days a week privately, part-time. If you can do the math, work it out. That's probably how you feel when you're doing your own work. So time is a real problem.
I think mine's more a comment and an add-on from yours, Viv. I'm a community lawyer at Inner Melbourne Community Legal, and I have clients who come to me and say, I've got a legal aid lawyer and they're not doing X, Y, or Z, or I've got a lawyer here and not doing X, Y, and Z. And I think something that you need to be aware of is, as you mentioned at the start, the difference between a grant of aid for a lawyer who's helping on an ongoing basis and a duty lawyer at court. Yeah. So a duty lawyer at court will see the person once off at court, and then the next time the person goes back, there's not going to be any background work done on that matter. And so I think a way that we can help our clients and you can help a client is finding out what sort of assistance the lawyer is providing, i.e. is it just a duty lawyer that the person saw, and then in that case can you speak to that duty lawyer and find out if there's something you can proactively do in the meantime before the next court date, or is it that they've got, they need to apply for a grant of aid, or do they need to go and see a community lawyer in the meantime? Yep. Because there is that difference between the level of service that a lawyer can provide, and often clients will say, they'll come and see me and then say, you're my legal aid lawyer, and I'm not from legal aid, and that's okay, but it's just this perception that we're all in the same boat, but we're not. We've got different requirements, different levels of assistance, and that's, as if you can find that out, that can, and even just calling the lawyer and saying, what are you doing? And it's not that I can disclose confidential information, but I can say I'm just acting as a duty lawyer.
Yeah, and look, that's important. Duty lawyers, by the way, there are two types of duty lawyers. It's not good ones and bad ones. It's legal aid to have a duty lawyer service, or so does the community legal services. But sometimes there is a private legal aid lawyer, a private lawyer who is acting as a duty lawyer, and on many occasions they can do the work as the duty lawyer on the first day, but then take the matter on under legal aid. So if you're lucky enough to get that process, that private lawyer doing the duty work, then that person can take that matter on and have that continuity. So yeah.
Also, there's a third type of duty lawyer. If you go to Melbourne Magistrates Court or Dandenong Magistrates Court, you might get a duty barrister.
Yes, sorry, I forgot.
And if they think your case is worthy, you may get them on an ongoing basis if you're lucky enough. Viv, can I just mention one thing which I think's been papered over in a few of the talks, and then get your comment on it?
Yep.
So, if an accused is found not guilty by reason of mental impairment in the magistrate's court, the only sentencing option is discharge. So that's the end of the case. No finding of guilt, no conviction, the end. So I wanted to say that. And also
there is an issue about that. The problem is that you've got to go through the process of showing the client has a mental incapacity, so that they either don't understand the nature of the act. This is not about unfit to plead. The unfit to plead is an appallingly difficult process. So if somebody says to you, let's go through unfit to plead, try and avoid it if you possibly can.
So it just so happens that in the break I wrote down the definition. This will just take a second, but I thought people in the room should hear it, because this is what you want to be telling your lawyer if they're not paying attention to you and trying to shoot for, in my view, if you've got the right client. At the time of engaging in the conduct constituting the offence, the person was suffering from a mental impairment that had the effect that he or she did not know that the conduct was wrong. That is, he or she could not reason with a moderate degree of sense and composure about whether the conduct was wrong. And this has been used, I have seen it, with a person with an ABI, terrible impulse control, nearly no impulse control. And it was said when this person went to lash out, they weren't able to reason that whether it was the right type of behaviour, and the person was found not guilty by reason of mental impairment. Now, I haven't ever seen it happen in the magistrates' court. I don't know it happens very often, but I feel that lawyers should shoot for that a bit more often. But it's hard, and you need a neuropsych report, and it takes time and messing around, and is a lot harder than trying for diversion or just pleading guilty and getting a slap on the wrist.
Yeah, look, that's right. That's when the neuropsych report is really, really useful, because it's saying the lack of impulse control. We don't need to worry about using it for mitigation. Just so, I'm well aware of the legislation, just to make it clear, you've got to have, mens rea and actus reus together. In other words, you've got to have the act and the intention to do the act together. one of the most famous cases went to the House of Lords, and effectively it was somebody being beaten up in an African country. The person died later, or they got pushed off a cliff. I can't remember quite which it was. They died later, and the defence was, well, they did the act, but they didn't intend to kill them because the mens rea, the intent wasn't coexistent with the act. Luckily, the House of Lords, because we don't go to House of Lords anymore, was really quite clever, and they found a way of bringing the intent to the actual act. But one of the problems that we find with intellectual people with IDs is that you can persuade them what they did was wrong. And then they make the error, your error, not theirs, that, oh, well, I did it, I was wrong in doing that, therefore my action occurred at the same time as my intent. And that's a problem. You've got to make it clear, or you've got to be very careful not to persuade that person to say, well, yeah, I knew it was wrong at the time. And that's really important with ID clients.
I had a client who went through exactly this process that you're talking about some years ago, and first thing I wanted to comment is that he actually went through the county court, not the magistrates court, and didn't have any access to this KISS program at the time. So I did have a question, is there a similar program in the county court? So someone can answer that question to me. And two, I think I recall that similar clause that Andrew cited and that you're talking about, and I think because he said there was intent, this is a young chap with exactly all those impulse control issues and underlying ADHD and a gamut of issues going on for him, and he was provoked and assaulted, was charged with assault. He ended off getting off with a suspended sentence, so it didn't work in his case, unfortunately. Okay. Yeah.
KISP is a magistrates court program. I'm fairly sure it's not in the county courts. In relation to the intent, yes, no, maybe. Sorry. We don't know the actual circumstances of the offence. We don't know how it was argued. I don't know whether he pleaded guilty or not. So an intent is often an intent to do the act, not an intent to actually harm somebody. So you can throw a punch with no intention of hitting them, but you hit them. You've still done the act, you've still got the intent to do the act. So I don't know the circumstances, so I can't respond to that query or that question.
Yeah, just to answer your question about the county court and KISP, I'll just do a little plug as to the program I work for. So I work for CROP, which is the KISP Remand Outreach Pilot. So we're a pilot program, been going about 2 years, based in Port Phillip, MAP, MRC and DPFC. So basically we do a similar assessment as to the KISP and credit bail workers for remanded prisoners applying for bail. So we do the assessment and help set up community supports for if they are released on bail, and we put in a similar report to the court advising the magistrate of those supports. We can also refer into KISP and credit bail if we think case management is required. In matters that are in the county court, this is where CROP is quite beneficial because we can help clients whose matters are listed in the county court. One thing with CROP is that there's no follow-up once they're released from custody on bail. So for matters in the county court, for example, we can't refer into KISP or credit bail for that case management, but we can still help set up support, so link them in with community services or help them re-engage with services they have been engaged with previously and advise the county court judge of what services they've got. Does that make sense? Have I? Yeah, so FYI, lawyers can refer, but the client can also self-refer. So if you do have contact with the client in custody, have a word to them or even contact us and we can go and have a chat to the client in custody about whether we can help.
Okay, just one last thing again. The resources are all hyperlinks, so when you get a copy of the PowerPoint, just click and go. Thank you. Chapter or last chapter? Same comment before.